Hello, everyone, and welcome to SCORE Fairfield County's live webinar on running a successful creative business. This is a three-part series, and today we are presenting the final part 3 on trademarks for creatives. I'm Bob Hogan, the webinar coordinator and a business mentor here at SCORE Fairfield County. And I'll be your host today, and our presenter is Cliff Ennico. More on Cliff in just a minute, but just some brief information on SCORE. SCORE is a nonprofit national partner of the SBA with over 10,000 volunteers across the country. Locally here at SCORE Fairfield County, we have over 100 volunteers with a wide range of industry process and subject matter expertise. And we offer 3 primary value-added services to small business owners. First of all, we offer free one-on-one counseling / mentoring, and you can access that in person, by video, telephone, email, whatever works best for you. And you can do that by clicking on the Request a Mentor link that you'll see on the screen. If I can ask Cliff to move the slide, thank you. Secondly, we offer a wide range of educational workshops and webinars like the one today, over 100 throughout the year. And lastly, we offer extensive website resources on our website, including access to subject matter experts. Our next live webinar will be in 2 weeks from today on Tuesday, March 11th at noon, when Dan DeSilva will be presenting buy-sell agreements, the business advantages and funding. And you can find specifics on that webinar on our website, fairfieldcounty.score.org. We also have a large number of recorded webinars on our website that you can access at any time just by clicking the on-demand button that you see on the website. Just some logistics about today's event. We have set aside time for Q&A at the end of the presentation. Cliff has assured me he will allow 5 or 10 minutes for that. And so if you have a question, you can use the Q&A button at any time during the presentation, and we'll take as many as we can and up until the top of the hour. Our webinar will end at 1 o'clock to respect your time. The session is being recorded, and a link to the recording will be available on our website within the next day or so. It is now my pleasure to introduce our speaker today, Cliff Ennico. Cliff is a nationally recognized small business legal and tax expert and is best known as the former host of Money Hunt on PBS, where entrepreneurs defended their business plans before America's toughest panel of experts. Cliff is an attorney and small business consultant based in Fairfield, Connecticut, and has helped launch over 15,000 businesses. He is also the author of 16 books, most recently the crowdfunding handbook, How to Raise Capital for Your Business Using Equity Funding Portals. I'll now turn it over to Cliff. Cliff, it's all yours.
Hey, Bob, and thanks as always for that wonderful introduction. And thanks to all the people, too. I see in the chat room a lot of, I think I have some friends, old friends here who are attending today. I'm always honored when people actually attend my programs for the second time. That's always a good thing. It means I haven't turned everybody off, at least the first time. One thing I want to just add to what Bob said, this is part 3 of a 3-part program, as he indicated. For those of you who did not attend the first 2 programs, you can catch them on the SCORE Fairfield County archive. The first program was on February 11th, 2025, which was just my personal thoughts about what makes a successful creative business, an artistic business. February 18th was our program on copyrights law, and that was February 18th of 2025. And this program is airing on February 25, 2025, and completes the 3-part series. While we may get into some copyright stuff on this program, and I realize a lot of people may have missed last week's program, I'm going to ask that you limit your questions and answers to trademark issues on today's program. If you want to ask a copyright question, great, but we're going to prioritize the trademark questions first, if that's okay. Okay, our usual disclaimer, I am a lawyer, so I have to tell you what I'm not going to do before I do anything. Basically, the most important one is the second one. We are going to get into some legal stuff in this program, but there's a very big difference between giving out legal information and giving out legal advice. Legal information is, hey, this is what the law is generally all about, and that's what we do in these programs. Legal advice is, hey, Bob, this is what you should do, and Mary, this is why you should do something else, and Josh, this is why you should do something else. I can't really give one-on-one advice on a program of this nature. So if you hear something in this program that sounds like a great idea and you do it and it doesn't work out and your business fails, you file for bankruptcy, your spouse divorces you, your kids don't want to know who you are, your dog's peeing on your leg and you're living in a diaper box under the Brooklyn Bridge, you can't sue anybody, okay, because of that. That's what this is really all about. All right, so let's talk about today's topic is trademarks. Last week we talked about copyright, which is how you protect and arrangement of words, basically, is what copyright is all about. Trademarks are different. When you're thinking about trademarks, you're thinking of names and specifically marks. Naming your business is one of the most difficult challenges that you have when you set up a small business of any kind. It used to be easy. Let's say you 50 years ago, when I was a kid growing up, yeah, right, I'm a little older than that. But going back, say, to the 1960s, when I was a kid growing up, if you wanted to start an antique shop, for example, it was easy to name your business. What you did was you took a little vacation. You went up to Vermont, New Hampshire, Maine, where there's lots of antique shops. Thought you found an antique shop with a name that you really liked. You came back and you called yourself that. Nobody cared about it back then because the place up in Maine, you're not stealing any clients from them. They're not stealing any clients from you. Who cares? No harm, no foul, as we say. Now, because of the internet, that little Maine antique store is now libertygibbet.antiques.com, and they're selling worldwide on eBay, Amazon, Etsy, and all kinds of places like that. And if they see you using their name for a similar product or service, they are going to go nuts basically on you. They're going to hire lawyers and make your life miserable. Sooner or later, if you don't really, pay attention to the name that you've set for your business, you will get a nasty, it's called a cease and desist letter from some law firm in some part of the country that you don't even know exists, saying that you're infringing their client's trademark. So it's a good idea to give some thought to trademark law when you are thinking about naming your business. Here are the 5 questions. Is your name memorable? I put this one first. It's not a legal issue, but a lot of people come up with very bizarre names for their company that the good news is you can trademark them. The bad news is nobody can remember them. So, for example, I have never trademarked Cliff Ennico. And there's a reason for that because people have trouble spelling it. Right now you're looking at my name, on the camera right here, but I guarantee that, 5 minutes after this program is over, you will forget how to spell my name. So a week from now or a month from now, when you want to send me an email, what was that guy that did that program for Score? Enrico, something like that. Okay, it's a difficult name to remember. That's why, the URL that I use in these programs is cliff@succeedinginyourbusiness.com, which is I used to write a weekly column for Creators Syndicate, and that was the website for that column. It's a longer name, but it's easy to remember, and that's important. Can you get a registered trademark? That is a trademark that is registered with the Patent and Trademark Office in Washington. Can you get the website URL, preferably the .com, because even 30 years into the internet, the search engine spiders are still programmed to give priority to .com URLs as opposed to all the other kinds. Is the company name available into Connecticut? And then is somebody else using the name for a similar business? It's a good idea to search the internet and see if there's anybody out there that's using the same name for a similar business. And you have to give some thought to who it is. If it's a little mom and pop in Utah, you probably don't care. But if Microsoft owns the trademark that you want, that's a big problem. Bill Gates has tons of money, and his lawyers will sue you if they see that you are infringing his proprietary name that he's registered with the Trademark Office. What exactly is a trademark? First of all, a trademark has nothing to do with ownership. You cannot own a name. You cannot own a word in the English language legally. It's a legal monopoly. Now, we live in a capitalist society. We don't normally like monopolies. Monopolies, raise, prices unreasonably for consumers. There's a whole body of law called antitrust law that is designed to sort of limit the number of monopolies we have in this country. But here's a situation where the government is granting you a monopoly for a certain period of years or for as long as you are using the mark in commerce. You have the exclusive right to use that name, that mark, on your products and services. And let me be very specific about this. We talked a few minutes ago about naming your business. You technically do not trademark a name, you trademark a mark, which is something a little different. A mark is something that you use in commerce. If I'm shopping in my grocery store and I pick up a box of your pasta and it says, Ronzoni on there, Ronzoni is the trademark for that brand of pasta. Now, the company that makes the pasta is some different name. It's, Associated Amalgamated Federated, something Inc. or something like that. That's a corporate name. And you can sometimes trademark a corporate name, but if you are not using it in commerce, you cannot trademark it. So, for example, Ben and Jerry's is a registered trademark, not because it's the name of the company, but because it's used on the ice cream containers that you get in your local 7-Eleven. Okay. You must use it in commerce. Unlike copyright law, which is for a set term of years, trademarks are valid for as long as you are using the mark. As long as you are using the mark, even if it's 100 years, you still have the right to that trademark, and no one else can take it from you or use it for a similar product or service. If you don't use it, you lose it. And that's very important. If you stop using the name in commerce, or if you allow too many other people to use your name for a similar product or service, the government will take that monopoly away from you. You can still use it, but other people now have the right to use the same name, and it's no longer exclusive to you. You lose your monopoly protection. If you are planning on branding your business, if you have any kind of business where you're looking to build a brand, and especially a nationwide brand, you need a registered trademark. That is Cliff Ennico's rule number one. The trademark is the most important thing, the most valuable piece of property that you have in your business is that mark, which has value in the community. I mean, I know businesses, consumer brands, where the trademark is the most valuable asset they own. It's not the inventory, it's not the equipment, anything like that. The trademark is where all the goodwill of the business is that you look to realize when you sell the business. One little thing, trademarks are technically for products. If you're selling a service, you can get a trademark for it from the federal government, but it's called a service mark and not a trademark. Okay. How do trademarks differ from copyrights? Okay. You trademark marks used to identify goods and services in commerce, brand names, logos. A trademark does not have to be words. It can be a graphic. The Pillsbury Doughboy, for example, is a registered trademark of Pillsbury, whoever owns them these days. The McDonald's Golden Arches are a registered trademark. It doesn't have to be a word. It can be a graphic. It can be a representation of something. But it has to be used to identify goods and services in commerce. It can't just be a name that you have, but you don't, that the consumer does not recognize. You copyright slogans and marketing copy and graphics other than logos. So, for example, Maxwell House Coffee, good to the last drop. Maxwell House is the trademark. Good to the last drop is a copyright. It's an arrangement of words in the English language that you copyright rather than trademark. Okay, you do not have to register your trademark with the federal government, although it's a very good idea. And if you have the money, you should definitely do it, especially if you're building a nationwide brand. Without a federally registered trademark, a nationwide brand is basically worthless, as far as I'm concerned. It's money you need to spend when you're launching your brand. Basically, it's identified, but you don't have to. You can claim a mark as a trademark without registering with the Federal Patent and Trademark Office. We call this a common law trademark. If you've ever looked at something and there's a little TM or an SM after the name, that's a common law trademark. What that says is, hey, we haven't registered this with the trademark office. Maybe we can, maybe we can't, but we are claiming it as a trademark. So if we see you using, our name for the same or a similar product or service, we're going to come after you. Our lawyers are going to come after you with baseball bats. That's basically what that little TM or SM is saying. You can still sue for infringement, but you don't have the protection that a federally registered trademark has. If you have a common law trademark and somebody else is using it and you sue, they have every right to come back and say, hey, wait a minute, we were using this mark in commerce before you were, we can prove it, and so you're infringing us. You owe us money, not the other way around. The federal R with a trade in a circle, whenever you see the R in a circle, that says that that's a registered trademark. That's registered with the trademark office, and that is holy. If you have a federally trademarked federal trademark, even if the person has used the mark beforehand, you still win that lawsuit. That is the basic difference between a registered trademark and a common law trademark. If you have only a common law trademark, it's very weak. It doesn't protect you. The federally registered trademark puts the burden on the other side to show that you clearly ripped them off, and that's not the case, you win. So it's something that's very much worth getting. Registered trademarks are identified by the R in a circle. It must be registered with the U.S. Trademark Office, which is USPTO, the United States Patent and Trademark Office.gov. not uspto.com. Unfortunately, in the early days of the internet, a lot of very bad people went online and registered domain names, .com domain names for government agencies. So, for example, if you go to whitehouse.com, you're going to see a lot of stuff going on there that has nothing to do with the Trump administration or anything like that. It's whitehouse.gov that you want to look at if you want to see what Mr. Trump is up to this week. USPTO.gov, there's a separate section on trademarks. You click on that and it walks you through some things you can do on there. Although, unfortunately, they changed their whole website last year. It's a lot more difficult to do trademark searches than it used to be. I'll talk about that in a minute. It is a federal crime to use the R in a circle if the trademark isn't registered. If you haven't registered your trademark, you cannot use the R in a circle. You have to use the TM or SM as a common law trademark. That's okay. You can do that, but you can't use the R in a circle unless you've actually gotten a registered trademark from the Patent and Trademark Office. You can sue others for infringement if they use the same mark for the same similar products, and no one else can use www.yourregisteredtrademark.com. If you are using a registered trademark as your domain name URL, and even if you're not, okay, you can block someone. So if I have the registered trademark for Liberty Gibbet Antiques, as trademark, and I see somebody else using www.libertygibbetantiques.com, I can call the domain name registrar and force them to re-register the name to me. I can take that name away from that other person because that other person is infringing my registered trademark, even if I don't use the registered trademark in my URL. So let's say, for example, that I claim Cliff Ennico as a common law, as a registered trademark. I register it, but I'm still using succeedinginyourbusiness.com because it's easier to remember. And somebody else goes out there and registers cliffennico.com. I have the power to call that other place's domain name registrar and force them to re-register the name to me because that other person is infringing my registered trademark, even though it's not part of my domain name URL. That's why when you get a domain name URL, let's talk about, well, we're not going to talk about trademark URLs right now. Whenever you have a name that you really want to protect, it's a good idea to get all the basic URLs. I mean, I do own cliffennico.com, .net, .gov, all of that. I own cliffordennico.com, Clifford R Ennico, because .com. I don't use these. I don't have websites there. I also own cliffennicosucks.com, by the way. And by the way, it is linked to my cliffennico.com site. So if you're searching for cliffennico.sucks, Cliffennico sucks, it will automatically turn you to my website. That's a cute little thing to do, by the way. Your web designer can do it for a few pennies. It's really easy. It's a lot of fun. All the trolls that are out there, it defeats them wonderfully. Even with a registered trademark, though, you can still be sued for infringement. What it does is it puts the burden of proof on them, though, to prove affirmatively that they were clearly using your trademark in commerce prior to the date that you filed your application for the trade. That's a very difficult burden of proof, however, and most of those lawsuits end up going nowhere. If someone was using your trademark first in a particular geographic area, they will be allowed to use that trademark, but only in that particular area. There's a famous case about 20 years ago, McDonald's, the burger place, sued a very small family restaurant in southern Illinois that called themselves McDonald's Family Hamburgs. It's an old-fashioned word for hamburgers. They had been operating in that location since the 1920s, which was much long before McDonald's was incorporated back in the 1950s, early 1960s sometime. So McDonald's went after them. They ended up losing the case. I mean, the courts basically said, it went to, I think, the Seventh Circuit in Chicago, and they said, this family restaurant has the right to use that name, even though McDonald's has the registered trademark. What they did was, though, they worked out a coexistence agreement, basically saying that when the last surviving member of the family died and was no longer operating the restaurant, then, they could no longer use that name. And McDonald's paid them some money for it. They probably paid their legal fees and did something like that. Whenever you see somebody using something that's really not hurting you in any way, it's a good idea to try to negotiate a coexistence agreement. That's an agreement that says basically that we'll use the trademark here, but you have the right to use the trademark over there, or a trademark license where, that person person gives you the right, to use the name. So you don't have to actually go to court. Lawsuits are very expensive. Federal trademark lawsuits can easily run $50 to $100,000. So it's not something you do for fun. Okay. How long does a trademark last? Okay. I said before that the trademark, well, a registered trademark lasts for as long as you are using the mark in commerce, which is true. But the trademark office does want to make money. So there are some rules. When you do get a registered trademark, it's good for 10 years and it must be renewed every 10 years. You can renew indefinitely. There's no time limit, not like copyrights where they expire and everything goes into public domain after a certain period of time, which varies depending on the type of copyrighted work. But you do lose it if you stop using it in commerce. You don't defend it against infringers. This is a very important thing, or you allow it to become generic. There are a whole lot of situations where names that were once registered trademark have been allowed to leach into the vernacular. So, for example, when you blow your nose into a soft tissue, you are blowing your nose into a Kleenex, even though the brand, if you look at the box, is not the Kleenex brand. It's another brand. There's a million brands of soft tissues, but they are all generically referred to as Kleenex tissues because the Kleenex company, whoever owned Kleenex back in the 1950s and 60s, allowed that to happen. When you have a registered trademark and you see other people are using the name for a similar product or service, you must send them letters and warn them that they are infringing your trademark, that they are doing so at your sufferance. And if they don't stop or do something or work out a deal with you, you will come after them and you will seek royalties, for the use of the name or force them to shut down in court. Yo-yo was once a generic name, but interestingly enough, not Google. The Google company has billions of dollars. Even though we commonly say, when we look something up online, we Google something, even though we're using Microsoft Bing or a non-Google product to search. And apparently, the court did rule in Google's favor, saying that that was still a registered trademark of Google Inc. So it's kind of interesting. I mean, we all use it. No one's ever going to do a thing about it, but it's kind of interesting. It just shows you if you have a lot of money, you have a lot of power, and you tend to win a lot more court cases than people who don't have money. That's always been true, by the way. Federal versus state trademarks. Most states have a trademark law that allow you to get a state trademark. It's a lot less expensive than getting a federal trademark. It's a lot less hassle, but it doesn't really give you the same protection. A state trademark in Connecticut only covers the state of Connecticut. So if someone across the border in New York, sets up a business with the same name as yours, there's not a whole lot you can do about it if all you have is a state trademark. Federal trademark covers the entire U.S., territories and possessions, Puerto Rico, Guam, any place where the American flag flies. But even a federal trademark does not protect you when you are doing business overseas. So let's talk about overseas. Okay, this is one of the biggest differences between copyright and trademark. In copyright, we don't worry about international things so often because there's something called the Berne Convention. We talked about it last week. Bern is as in the capital of Switzerland, Berne. It was first passed in 1886, and it basically says that if you have a work that is copyrighted in one country, it is automatically copyrighted in all the other countries that are signatories to the Berne Convention. So if someone buys the German rights to your book, that's published in the United States, you do not have to get a separate copyright in Germany. It's automatically copyrighted, although the German translation may have to be copyrighted there, which is a little bit of a wrinkle in the law. And virtually every country in the world except North Korea, Cuba, and I think Iran have signed the Berne Convention. So, you're pretty safe with copyrights. Not so in trademark. There is no one treaty that covers the trademark universe in the same way that the copyright is. There are several international treaties. If you go to this particular website, for example, it's a nice article that describes the different trademark treaties that the U.S. is a party to and what countries they cover and everything like that. But you still have to register and identify the participating countries where registration is desired. So, for example, if I have a trademark in the United States and I start using it in France, I open an office for my business in Paris and I want to use the same thing, I have to register that trademark in France and also any other countries in the European trademark treaty system that I plan on. I believe all the EU countries have a common trademark law, but don't quote me on that. I'm pretty sure they do, but I'm not 100% sure. I haven't looked at it in a while. But you have to designate the country. So I'm not automatically covered in the entire EU. I would have to designate France, Italy, Germany as the countries where I want my trademark protection. And not every country has signed a treaty. Trademark law internationally, it's all over the place. The bottom line is you really need to talk to a lawyer in that country and find out what the trademark law is and how broad it is. There's no alternative to that, unfortunately. Okay, so now let's go back. So now you want to name something. Maybe you want to name your company. Maybe you want to, put it on, slap it on your products and services. You're naming a product, a service, a publication. The first step is you have to ask, is the name trademarkable? Not every name it can be trademarked. The name, for example, cannot be a generic term. So California Vineyards would not be a term. Anything that is merely descriptive, like web graphics or geographical. Nantucket Nectars, believe it or not, that's an actual product, is not a registered trademark. If you look at the bottles, it says TM and SM. On it. They're common law trademarks because they can't get the trademark for the name Nantucket. It's juice products that are made in Nantucket. I mean, that's basically it. You cannot use a surname. So Joe's Garage. If you are a mechanic and your name is Joe and you have a garage, you cannot trademark Joe's Garage for your garage. Interestingly enough, though, somebody does have a trademark for Joe's Garage. But not for automotive products or anything to do with cars or trucks. It's the estate of Frank Zappa, the rock musician. One of his albums was titled Joe's Garage. So he actually got a registered trademark from the government for music and for music recording and music related, products and services, nothing to do with automotive. If your product or service is totally unrelated to the trademark that you are selecting, you could possibly get a trademark for it. And that's a very good example. If the trademark is immoral or offensive or scandalous, back in the 1980s, I have a friend who collects beer bottles. That is his thing. He looks for rare ones on eBay. And one of the holy grails for a beer bottle collector, apparently, in the 1980s, there was a very small brewery, a craft brewery in Michigan somewhere, that decided to create a beer called Bad Frog. And the beer itself was like any other beer, that you'd get. But the label showed a picture of a frog sitting on a lily pad with his hand outstretched with the middle finger sticking up. Okay. Basically a frog that was telling the world to go like that. Okay. Well, the state of Michigan shut them down. Like about 3 weeks after they started using this, they said, you cannot do this. I mean, the federal government didn't go after them, but the state of Michigan did and forced them to go out of business, but not before they had released about 500 cases of beer with this label on it. So if you own a 6-pack of Bad Frog beer, okay, that you probably could get about $500-600 on eBay for it, whether or not the beer is still in there, because the value is in the graphic, not the beer itself. Okay, so that's an example of an immoral or offensive. So, for example, using the F word or in a trademark is not going to fly. The trademark office will not allow that. Anything that's deceptive, false connection, or disparaging, of other people, people's ethnic groups or anything like that, that is not going to fly. The likeness of a living person without their consent. So, for example, I mean, during the 1970s, when the late Jimmy Carter was president, he had a brother who was kind of a wild guy, and he issued some beer called Billy Beer. And that did pass muster. They were able to get the trademark because it didn't specifically refer. But if they had referred to Billy Carter beer, that would not have flown. You cannot use the name or a likeness of a living person unless they have given their consent to it. What about deceased people? Well, there's a whole lot of case law involving estates. The trouble is, in most cases, though, the trademarks to a lot of celebrities are owned by their estates. So, for example, you could not really do something with Elvis Presley's likeness on it, or Marilyn Monroe. If it's a celebrity, a deceased celebrity, or political figure, their estates probably own or have rights to the trademarks, and you have for that name or that likeness. So you'd have to get their permission. But there are exceptions. There is a brand of wine called from California called Marilyn Merlot, which apparently has the consent of the Marilyn Monroe estate to use her name and license on the labels. I mean, it can be done. You just got to cut a deal with them. And, if it's somebody that nobody remembers, they might, if you wanted to do a beer with Millard Fillmore's, portrait on it or something, I don't think a lot of people are going to complain. The biggest complaint is, who the hell was Millard Fillmore? Answer 13th president of the United States, by the way. A name may be trademarkable if it is suggestive. So Mustang for cars, we're very fast and we're wild. Copper tone, you'll have bronze looking skin. If the name is arbitrary, that's the best trademarks are the ones that have nothing whatsoever to do with your product or service. What does Monster have to do with looking for jobs online? What does Penguin have to do with books? What does Camel have to do with cigarettes? Do camels smoke cigarettes? The answer is no. Fanciful or coin named Exxon, eBay, these are names that are made up. A lot of tech companies use names with a lot of X's and Z's and stuff like that. Just make sure, again, that your name is memorable. If people have to think about the name, it's probably not, you probably could get a trademark. It probably would be very easy to get a trademark for it, but nobody's going to remember it. So what good is it? Okay. So anyway, so that's step number one. Is the name trademarkable? So now you've passed step one. You have a name that is clearly trademarkable. Your lawyer or somebody else does a quick and dirty search, and nobody has a name that's anywhere close for this, for the same products or services. So now the second question is, has someone else trademarked the name? Okay, a name cannot be trademarked if it is confusingly similar to another registered trademark. So, for example, if I go to the supermarket and your products and somebody else's are side by side, and people are making mistakes, they're picking up the wrong box by accident, that is a trademark that usually will not be allowed. And the PTO examiners have extremely broad discretion to make this determination. When you file for a registered trademark, it doesn't just go through a computer. There's a human being who actually looks at this and does a search. And if they think that there are other marks that you are potentially infringing, they will send you a letter saying, please demonstrate how your mark is distinctive from these five, marks, and they'll give you names and numbers and stuff like that. I always tell people that when you're looking to do a federal trademark, especially if you're looking to build a national brand where the federally registered trademark is essential to the product or service's success, hire a lawyer to do a thorough trademark search. The Patent and Trademark Office does have a service called TESS. It says Trademark Examiner Service something. You'll see it. You can do it yourself. You don't have to, there's no charge for it. You can go online and do a basic trademark search, but it's not very reliable. If you don't do it right, it will only show you trademarks that are made of words. As I said earlier, the Trademark Office last year changed their software, and it's a lot more difficult now for non-lawyers to do trademark searches. I have difficulty doing them now, which I didn't used to have before. If you used to be that if you searched for Liberty Gibbet Antiques, the first thing that would show up is another company that's using Liberty Gibbet Antiques. But apparently, when you do it now, you have to put certain codes in there. Otherwise, it will show you anything that has a combination of Liberty Gibbet Antiques. And so you may end up looking at hundreds of hits that aren't really hits. I'm not a big fan of what they did last year, unfortunately. It's made the process a lot harder. You really need to hire a lawyer now before you can really know that a trademark search has been thoroughly done. Okay. Okay, let's do this. Okay. Okay, but so let's say that you do look online. Let's say you do look at tests, or a lawyer comes back and says, hey, thumbs up. I couldn't find anything that's even close to this. I think you have a good shot at it. Consider doing it. Spend the money, but don't do it yourself. Okay. You have a choice here as to what you can do. You can hire a trademark attorney. The cost is usually somewhere in the $2,000 to $3,000 range, unless they have to do a very extensive search. I mean, I work with a lot of trademark lawyers. I personally do not do trademark registrations anymore for my clients because they're too time consuming. But I work with a lot of trademark lawyers who do nothing but this for their clients. And they all tell me, if I do a trademark search and I come back with more than a dozen hits, I am not going to waste the client's money looking at all of these things. I'm simply going to send the result to the client and say, you know what? There's 50, 60 hits here. If you want, I'm happy to take the time to look at them. Here's how much it's going to cost. But I really suggest that you find another name here because there are just too many things here that are too close for comfort. Find something else. Trademark law is it requires a different brain than other areas of the law. I mean, a lot of trademark lawyers and patent lawyers are former engineers, and they have that same kind of brain. If you remember those awful spatial relations tests that you used to take in high school, now here's a figure. Which of the following four figures shows it turn 90 degrees to the left or the right, upside down? If you remember those tests, those are the people that do well on those tests become trademark lawyers because it's basically, okay, now this symbol and that symbol are pretty much the same, except that one's a little different. That's got a hook on it. Is that enough of a distinction to avoid infringement? That's the kind of brain that they have, and that's the kind of exercise that they do dozens of times every day. I don't know how they do it, to be honest with you. It takes a very special personality to do that kind of work, and I personally don't have that personality, to be honest with you. But you don't have to hire a lawyer if you don't want to. If you know that you have a name that's trademarkable and nothing is even close to it, and that's registered in the trademark office, you can hire a trademark service. LegalZoom, the company that registers LLCs and corporations, does also do trademark searches. The cost will be a lot less. It'll be somewhere between $50 and $250. But here's the thing. The service will not take you all the way. If they'll do a quick and dirty search, they'll give you a thumbs up. You pay them your $200, and if the thing sails through and gets registered, well, congratulations, you've saved a ton of money in doing that. But if the trademark office raises objections, if they come back with a comment letter saying, hey, we've looked at this, we find that there's problematic here, they'll be very specific about what they're concerned about. The trademark service will not fight that battle for you. What they'll do is they'll call you and they'll say, hey, we just got a rejection letter from the trademark office, or a comment letter with some comments and questions. You better get an attorney to respond to this. They'll chicken out on you. That's the difference. That's what you're not getting. Whereas a lawyer, if they were the ones who filed the application, they stand behind that and they will fight that battle with the trademark office for you. So that's the trade-off, if you will, that you have, in using a service as opposed to an attorney. What if your name can't be trademarked? Let's say that you do get that comment letter and it's quite clear you're not going to be able to get it. Well, you can withdraw the application at any time, or it expires if you don't respond to the comment letter within a certain number of days. I don't recommend that. If you're going to withdraw the application, withdraw it, because otherwise it could be with prejudice. So you wouldn't be able to file another application later on. If you can't get the R with a circle, well, maybe no one else can either. Maybe the name is not trademarkable and you can use a common law trademark. That's one possible reaction to that. See if anyone else is using the same or a confusingly similar name. Do an online search for the name, do a thorough one, try to see if it's out there. And then if nobody else is using it and you can get a common law trademark, then market the hell out of it so that anybody who's thinking about using a similar name will see that you got there first. That's the best way to deal with a situation where you can't register the trademark. But be prepared to change your name if someone much bigger than you sends you a cease and desist letter. I mean, whenever you do a common law trademark, there's always a risk that someone out there is going to think that you infringe their proprietary trademark. And if they're a lot bigger than you are, you simply don't have the money to fight that battle. Or better yet, find a name that is trademarkable. Okay, there's lots of them. All right, let's talk about logos as trademarks. I'm not going to spend a lot of time on this, but I know that whenever I do this program, there's always a few people in the audience who are graphic designers who do logos for their corporate or business clients. So trademark law is a very important issue for them. So this section is really for them. A logo is a type of trademark that consists of a design that is generally used by a company and placed on its products or printed material related to its services. So, for example, if I have a design or a logo that I have trademarked, but I'm not using it on my stationery or on my product labeling, my packaging, I'm not using it in commerce. Sooner or later, I will use it. I will lose that exclusivity, and other people will have the right to use the same name for a similar product or service. The logo may be a design by itself, a design with letters or words, or a design consisting simply of stylistic words or letters. So, for example, Nantucket Nectars, I used them before. You may not be able to trademark the name, but if you did a fancy logo or a graphic that incorporated the words Nantucket Nectars, you might be able to trademark the logo with the words included. You might be able to do that. And that's a little workaround. Trademark lawyers are very good at this. They'll say, you know what, the name is problematic, but here's what I would suggest. Get a really great graphic designer to design a logo that incorporates the name, but do it in a certain font, a certain format, a certain color, whatever. So for example, the word eBay, eBay in black and white is not if you use that way, that is not considered to be an infringement of the eBay trademark. The eBay trademark is the four letters in the different primary colors. I wrote a book years ago called The eBay Seller's Guide to Tax and Legal Issues. It's still in print today, though I need to update it a little bit. And this is one of the big issues. My publisher had to deal with eBay's legal department saying, look, he's writing a book about eBay. He cannot do it without having the word eBay in the title. How do they do it so that how can he do it? And they gave him guidance as to the publisher guidance as to specifically how the word eBay should appear on the cover and in text so that it doesn't constitute an infringement of eBay's proprietary trademark or imply that eBay is endorsing what I was doing. That was another big concern that they had. I had to put disclaimers all over the place saying that, eBay is not, although they love my book and they actually recommend it to a lot of their sellers, but they don't want to endorse it. They don't want to say, well, Cliff Ennico is our guy. They didn't want to imply any relationship, which I don't blame them with. Take a look at me. Would you want me representing your products or services? My celebrity likeness feeling all over the place? I really don't think so. I don't think it would be a good business decision. I'd love to do it, by the way, and I'll charge you lots of money for it, but I don't think it would be very good. Anyway, some trademarks consist solely of letters of words without any design, but these would not be considered logos. Logos always have a design, a graphic element. There are three types of logos. There are font-based logos. These are words or initials with a distinctive font. So eBay, Sony, Microsoft, IBM. Illustrative logos, graphics that illustrate what the company does. So a picture of a brush for a house painting company. You remember the old telephone directories? They'd always would have little things, the guy with the ladder who's a handyman, that kind of thing. It graphically illustrates what the company does. Abstract graphic logos, they have nothing to do with anything like the Nike swoosh, the McDonald's golden arches. The more abstract the logo, the more likely it will be trademarkable. Should you help your client figure out whether or not a logo is trademarkable? If you are doing a logo for a client, okay, the question, if you are a designer, it is not your responsibility to determine whether or not a logo is trademarkable. The client and its trademark attorney makes this determination. What most designers will do is they'll offer several designs. They'll send it to the client. The client, if they're smart, will run them by their attorney, and the attorney will say, yeah, this one, number 5, is your best bet here if you're going to do a trademark registration. But you need to ask up front, number 1, does your client want a trademarkable logo? Some clients don't care, but you should ask them. And if they do, and you do the trademark search for them. Question number 1, are you practicing law without a license by doing a trademark search? The answer is technically no. But be careful, because if you do a trademark search and you come back and say, hey, I think this looks okay, the client has the right to rely on that. So if they buy your logo and they go and somebody sends them a nasty cease and desist letter, if you told them in writing that you believe that this was trademarkable, they have the right to rely upon that, and they could sue you for that, for malpractice, basically, for negligence in preparing their logo. Another thing, by the way, whenever you do, keep in mind that because you are an independent contractor, you technically own the rights to that logo until you assign it to the client. So your standard client agreement should have a clause that not only saying that, I'm assigning, all my rights to my work product, to you, once I get paid, of course, once I get payment in full, you own the rights to the logo. You can do whatever you want, but I make no warranties or representations. Whenever I represent graphic designers, I always put a clause in their contract saying I make no warranties that any work product infringes any trademark or copyright of any third party. I don't want my clients getting into that kind of a fight with their clients. The client needs to be put on notice that it's their responsibility to determine whether something is trademarkable. But even if the client doesn't care, good customer service may dictate that you do a quick and dirty trademark search if time and budget permit before recommending a logo design to the client. Consider now, here's a situation where those cheap trademark services can help you. Rather than hiring them to do the registration, if you're a designer, spend $50 to have LegalZoom do a quick and dirty trademark search. And if it doesn't come back with anything, you could perhaps rely on that to say, hey, I just did some quick and dirty searches online. And of course, you pass that cost on to the client. That's where you might be able to use the cheap trademark services as an ally to help you protect yourself in case you do a logo and it turns out there's a trademark issue. So how do you do a quick and dirty trademark search for logos? This is a quick and dirty guide to using the Patent and Trademark Office website. After you practice it a few times, you can learn how to do it, but keep in mind, they made some changes last year that have made this process much more difficult. Searching words is word-based trademarks that are nothing but words. That's fairly easy, but the minute you start getting into designs, you have to learn how the trademark manual works. What you have to do, let's say, for example, that your client wants to use a green six-pointed star as their logo. Okay, what you have to do is you have to go to the website, and you don't just search for green six-pointed star. You have to actually insert codes, which you can find at the Patent Trademark Office's Design Search Code Manual, which is available online. It's a free download. It's about 300 pages. And basically you have to use the codes for it. So a five-pointed star would be category 01, which is celestial bodies, division 01, and section 03, which is a complete design code of 010103. And if it's green, it would be 01010306, which is the code for green. With a little practice, you'll get good at it. It's not rocket science to do it, but you have to learn to think in codes and not in words when you do a design trademark search. No matter how hard you try, though, you will never be able to do a thorough enough search. Do enough so that you avoid obvious clients, and then let the client's attorney do the more thorough search. Or if clients routinely insist that your design suggestions be trademarkable, ally yourself with a trademark service. Call them up and say, hey, look, I'm going to be doing a dozen trademark searches a month. Can you give me a break on your fee? I'm a volume customer, and see if they will do this for you. Use those services as an ally, just to do quick and dirty service searches, so that you're not sending sending a client a search that is an exact replication of the McDonald's Golden Arches. That's a total waste of time and money. And then my tip is, don't tell the client that you did this, because that could become a legal warranty that the logo is trademarkable. If you put something in writing saying, hey, I searched the trademark records and it looks okay, that is a warranty that the logo is trademarkable under federal law. And that is a legal opinion, which you as a non-lawyer are not qualified to make. So be very careful. My tip is, don't ever say that you did a trademark search. Do this behind the scenes, pass the cost on to the client, but don't let on to the client that you did it, because then the client can rely on that. Okay, so here are my tips for trading trademarkable logos. Look at the logos of your client's competitors. They're the ones that are most likely to sue if there's a problem here. Make sure your design isn't confusingly similar to theirs. Avoid logos that are merely descriptive. Make your designs as abstract as possible. Avoid trendy looks. That's not a legal thing, but trademarks are designed to stand the test of time. Don't use clip art if your client wants to trademark the logo. There are various services and websites that offer downloadable clip art, certain generic, graphics and stuff like that. Those are meant to be used and copied. They are not trademarked. They are not copyrighted usually. So the thing is, a client cannot get a trademark using a graphic that is, owned by somebody else or is public domain. So don't use clip art if the client wants to trademark the thing. So here are my key takeaway points. We're basically done. Pick a name that is trademarkable. memorable and domain nameable. That's not a word, but can you get the domain name URL, especially the .com, with the registered trademark in it? And by the way, whether or not you are planning to use the registered trademark as a domain name, register the trademark.com name, even if you don't plan to use it. Like, my CliffordREnnico.com is a good example. I mean, I own about 50 different domain name URLs that I'm not planning to use, but I just want to make sure that nobody else gets the name. CliffEnnicoSucks.com is a good example of that. Use your mark in commerce aggressively, whether you register or not. Hire a lawyer to do a thorough trademark search before you register. I mean, around here, the typical cost will probably be in the $1,000 to $2,000 range, again, depending on how many hits they have to look at. Do not attempt to register a trademark without professional help. And when designing logos for clients, consider working with a trademark service so you don't have to do the searches yourself. They do hire young attorneys, usually people that are fresh out of law school that have taken a basic trademark law course to do this kind of search work. They're better than you. They may not be perfect, but they're better than you are. So you use those resources when they are there. And this is my contact information. If you want to reach me, I do answer basic trademark questions for clients, but I will not do a trademark search for a client. I will not do that, that they can rely on. I may do a quick and dirty search just to give you a general sense of whether something's okay. I will charge you for my time if I do that. But I'm not really a trademark law specialist, but I will be happy to refer you to somebody, and I don't charge any kind of referral fee for that. So with that, Bob, why don't we look at some questions? It looks like we have a few questions here, and there may be some copyright questions in there, but let's do the trademark ones first, because that's what this program is supposed to be about.
We will definitely prioritize the trademark ones. Just as a reminder, if you want to ask a question, please use the Q&A button, and we'll take as many as we can up until the top of the hour. The first one is from Kyle. Let's say a person trademarks a small business LLC name, but the person also wants the option of sometimes using the contraction/acronym of the full name as a DBA identifier, doing business as. Should the person also trademark the contracted version of the name? And also, should the person somehow designate the LLC as the owner of the name, say for liability and succession purposes? So,
okay, well, two very good questions. The first thing is, if you are using both the full and the contracted version, on your products and services or on your website or identifying yourself in commerce, the answer is you should trademark both if you're using both of them. So for example, the contracted version may not be considered the same as what appears on the trademark register. It may be whenever you register a trademark, you have to use exactly what appears on the trademark register. If you're doing a variant or a variation of it, that is considered a separate trademark, and you have to do a separate filing for it. That's the easy question. Now, should the person somehow designate this? The answer is yes. This isn't like patent law, where the patent must be filed in the name of the inventor, not the company that's actually exploiting it. Trademark law is very different. You can trademark. In fact, it's very common to trademark something in the name of your LLC or corporation. I personally like that approach, because let's say you do goof it up and you do infringe somebody else's trademark. That way they'll be suing your corporation or your LLC. They will not be suing you personally. So the answer is yes. It's probably the preferred way to go.
Makes sense. The next one is, I think it's from OP, and I think it's when you were talking about common law trademarks, and the question really is quite simple. How can you prove you used it first?
That is a very tricky question. The answer is any way you can. Okay, so let's say, for example, you put it up on your website, for example. Ask your web designer. They usually do this anyway, but they can put a date and time stamp showing when that was first put up on your website. Whenever you make changes to a website, there's a way that your web designer can date and do a date and time stamp. It doesn't appear to the user, but they have it in their records showing that you first put this up on your website on thus and such a date. That would be considered good evidence in a court of law. But otherwise, any way you can. So if you have a copy of a letter that you sent to someone, on your stationery, you use the trademark on your stationery. I mean, you can do the trick that you can do with copyright, for example, where let's say it's your corporate logo, you put it on your stationery, mail a few letters to yourself using the logo, and when the letters arrive back in the mail, do not open the envelopes. The postmark will indicate that you do that. We can do that with copyrights as well, but you can also do it with trademarks as well. Any way that you can document that on thus and such a date we're using, that will help you in the case you get sued for infringement.
That's great. Very helpful. Next one is from Argery. What if I have a registered trademark that has an image, name, and tagline all in one? The name has company, CO period, instead of company written out. What if someone uses company spelled out? Could I make them stop using it? So I think it's the...
Yeah, that's a more technical question, but the short answer is if the only distinction is the fact that they used company written out instead of CO period, I don't think that would fly. I think you would still be able to sue for infringement if that was the only change. Now, if they made other changes as well, if they changed the green star to a red circle or sphere or something like that, if they made other design related changes, a task that trademark lawyers are sometimes asked to do is, hey, I want to use this particular trademark, but I know it's too close to this other company. What do I have to do so it's distinctive enough from the other mark that I won't get sued? And the attorney will offer advice on that. That's why I say trademark attorneys often have a design and an engineering background that would help say, okay, well, change this to that, change this to that, change that, and I think you're okay. You're distinctive enough that your trademark should be able to stand on its own. It's worth paying a trademark lawyer to advise you on that if you're in that situation.
Great. Next one's from Jeff. What if you sell a product and a service? Do you need a trademark and a service mark? For example, an interior design service that provides furniture and decor with the service.
Okay, that's a good question. You can use both, but most people don't. Most people would do the TM for the product and not worry about the service. The service is ancillary to the furniture. You're offering a service, but your real goal is to sell the furniture, whatever the primary activity is. So, for example, if you're an interior designer who recommends, items of furniture that you buy, who makes recommendations and then goes out and buys the furniture on behalf of the client, which a lot of interior designers do. The service, I think, is prioritized over the furniture. But if you're a furniture manufacturer that offers some related design advice, but for the sole purpose of selling the furniture, the TM, I think, would be the dominant thing. Figure out what is the dominant business that you are in and then go accordingly.
Next one is from Joanna. What are the advantages, disadvantages, and potential legal implications for using a full name versus choosing a distinct company name? Not sure I follow that one.
Well, I don't know where we're going with that, but let me just put it this way. If you have a name that is difficult to spell, like mine, believe it or not. I mean, there are a lot of attorneys I know with a name like Brian, Orzechowski, something where the name is all X's, Z's, and Y's or something like that. I mean, you certainly can trademark that name. You can certainly use it as a domain name URL, but no one is going to remember how to spell it when they're trying to get in contact with you. So you might want to do something like Brian, the trademark guy. .com or something like that, which is a little bit longer, but it's easier for people to remember. And a lot of attorneys do that. There's rules. If you are a professional, by the way, most professional rules of ethics have rules about how you can name your business. So make sure. So for example, if you are a lawyer, the model rules of professional ethics have very specific guidelines for what you can and cannot do with law firm names. And I think every profession has a set of rules like that. So just be sure you're mindful of that if you are a professional.
Joanna has a couple of other questions, but in the interest of time, I think we'll get one in from Michael here.
Sure.
When you were talking about withdrawing a trademark application, you said if you're going to withdraw the application, withdraw it because otherwise it could be with prejudice. You wouldn't be able to file another application later on. What did you mean by that?
Well, again, it depends on why the trademark office objected to your initial application. There are two kinds of trademark objections. There are some that are easily addressed. So, for example, if the trademark said, hey, we like it, the logo is basically okay, but you got this little curly Q over there that makes you look a little too close to this other thing. They sometimes will give you guidance. Then simply get rid of that curly Q and you're okay. And then you'll resubmit it and as part of your application, file an amended application and you're okay. But let's say the objection letter comes back and you says, it's just obvious that there's just no way you're going to get the trademark. They will let the application expire if you don't respond to it within a certain number of days. But if they do, sometimes it can be with prejudice, which means that you could not submit an application for the same or a similar mark later on. So I always advise clients, when you're in that situation, it doesn't cost you anything except your attorney's fee, of course, but file a withdraw the application. And then when you've fixed whatever the problems are, resubmit it as a brand new application rather than as an amendment of the existing. Again, it all depends, and this is why you need a trademark lawyer. How serious were the objections? Are they really saying here that you don't have a trademarkable name or a logo, or are they saying just fix a few things and you'll be okay? Those are two different sets of circumstances, and your attorney has to give you guidance as to the best way to do it in that way.
We'll end with one quick one from Kim. Can you trademark a logo that doesn't contain any text?
Oh, yes, of course. The Pillsbury Gold Boy doesn't have any text involved. Yeah, you absolutely can. I mean, back in the old days, a lot of people couldn't read, a lot of the new immigrants to the United States. That's why if you ever look at a box of Ronzoni pasta, you'll see there's a number on it, Ziti number 36, rigatoni number 47. What do those numbers mean? Answer: 100 years ago, when the Italians were, immigrating en masse to the United States, they didn't read English. They were illiterate, most of them. They couldn't even read or write Italian either. So those numbers were a way of helping them determine which pasta they wanted to buy. Hey, Giovanni, go out to the store, give me number 30, give me 3 boxes of number 36. They did that back in those days, and that's why that's like a little vestige. So yeah, the answer is you don't have to use words at all. In fact, if you're dealing with a population that doesn't know how to read and write, that could be a great logo is one that doesn't have any words on it. So if that's any helpful. So
Unfortunately, we are out of time. Just a reminder to everyone that the webinar has been recorded, and the materials will be available in the next day or so on our website under recorded webinars. Our next live webinar is 2 weeks from today, March 11th at noon, when Dan DeSilva will be presenting buy-sell agreements. And again, you can find more specifics on our website. Again, if you would like to take advantage of the free individual counseling, you can use the link that we showed on the screen earlier. Just hit the request a mentor button. And if I could also ask you to please fill out your evaluations that have been sent at the end of the webinar. They're very helpful to us going forward. And on behalf of SCORE, thank you all for attending today's live webinar. And in closing, a big thank you to Cliff Ennico for presenting today. Thanks so much, Cliff.
You bet, and thanks, and good luck to everybody. And I hope to see your mark soon in my favorite store.
Great. Enjoy the rest of your day, everyone. Take care.